I don't know at this time, not positive, but we can keep it.
It's on the bench trial calendar. It's gonna go back on the bench trial calendar. Do you know?
I believe so. Let me see.
Okay, I'll just make a note. I'll find it out.
I can double check too.
It is? Okay, all right. Position number 2, Marcus Rodriguez.
Judge, Mr. Riser and I have a negotiated course consideration.
Okay, very good. I have it, and I'll take you first as soon as I complete the calendar. Position number 3, Chauncey Yongo.
Thank you, Judge. We are going to be objecting to a bench trial, Your Honor. The victim does live out of state. She's present on Zoom. We would need a specially set date for her to be able to fly in for the trial. So we are either asking for a reset and or a jury trial date.
Judge, if the state had a served subpoena with the return filed, I wouldn't have an objection. However, they don't have that. What they have is a delay because they want to get their witness here when they've had this on notice for some months. We would ask the court to deny the motion to continue for that reason, and we would ask the court to deny the request for a jury trial. The time for that was back when we asked for the bench trial and waived our right to a jury trial. And under 1774, which was in effect at the time of the arrest, the state does not have a right to a jury trial in any case but a serious violent felony. That was this case comes from 2021, and this case was accused shortly after it went into effect. Well, I would suggest to the court that there is no right of the state to a jury trial in this case.
I may respond, Judge. Under Zegan v. State 281, Georgia 415, as well as Smith v. State 295, Georgia 120, that actually states the inverse kind of what Mr. Corn had just cited, that a bench trial is not a guaranteed right of defense. You have to have the state consent to do a bench trial. And it's my understanding that I don't have the consent and I don't have to object to it at any particular time, just prior to if the bench trial is going to happen. And so as of this point, the state would be objecting and we're asking for a jury trial. As the case is by now, the state's consent, why that's a requirement is that one is not a guaranteed right by the defendant, that's only a right to a jury trial. And 2, the purpose of the state's consent is to make sure we are all, both the government and the defense are all on the equal playing ground. And that's a direct quote from the cases in Supreme Court.
So let me just say this, Ms. Reiser. I don't disagree with you. My problem is this case is back from 2021. We're here to resolve cases in the Orca trial. We put this case on a bench trial calendar. There was no objection. I looked in the file today until yesterday to us having a bench trial on this matter. Yes, you're right. You have the right to have your jury trial. But what I'm concerned about is we've got this gentleman that's down here. He's all ready to go. He's been under these charges for such a long time. And we've been here before with these types of cases. And I know this is not your fault, so I'm not getting on to you per se. But my job is to move these cases and to look out for everybody that's involved.
I understand, Judge, and I apologize if there was a delay. And I will say, in addition to, I think our victim does have a right to be here as well in person and confront her accuser and testify. And I know the court's not saying that. I just wanted to articulate that for record purposes.
I want everybody to get their day in court. I mean, that's why we're all here. That's why I'm here. I just want it to be fair to everyone. You understand what I'm saying? I want it to be fair to not only your alleged victim, but I want it to be fair to Mr. Yongo, also, because no one wants to be under this type of, and he's ready to go. They requested a bench trial. I wish, and in the future, if you could let your office know that when a bench trial is requested, if you don't want a bench trial, just tell me you don't want a bench trial and I'll put you on a jury trial calendar. I mean, you all know how easy I am about those kind of things. But I guess what really bothers me the most is that everybody has to be considered. And that certainly includes Mr. Yongo, who has the most to lose from all of this. So again, I'm not getting on to you. But I just want to make sure that in the future that it's just fair to everyone. I don't see that I have, and I'm sorry, Mr. Corn, I am going to grant her the right to have her jury trial in the matter because I believe that she has a right to that. Please let your office know that this is not the first time that this has been a problem coming to, and you've got plenty of time. What I'm going to do in the future is like when a bench trial is requested, I'm going to ask at that point in time if there's any objection. If there's no objection, and I would think that you all have the right. I know some cases you don't want to have a bench trial in. When I saw this on the calendar, that's why I went and checked. And and if you could have just done it a week before, so we didn't have to get this man down here, today, just not the day before. So, Mr. Yongo, the court apologizes. I'm sorry that that you're here today, that you're ready to go. I am going to reschedule this for the next available jury trial calendar.
If that may be real brief.
Yes, go ahead.
The statute I cited was placed in effect, it was passed by the legislature because of COVID and because of the very reason that Orca exists. I don't know the year that those cases that she cited, I noted she didn't say them out loud, but I would like to know what year are those cases?
I think Zigan, I pulled up maybe early 2000s. I think Smith, maybe 2014.
I would submit to the court that those cases are inapplicable because the statute was since enacted to modify that rule. I don't believe that they're appropriate. I don't believe that the state's reliance on them has any grounds for delaying this case at all. And let's be honest, this case, they're not asking for a jury trial because they have a right to a jury. They're asking you for the purpose of delay. They want time to get their witness here because they didn't do that before now. I believe I have a right to be heard on this, Judge. I believe that Mr. Yongo has a right to a trial at this time.
Okay, and I understand what you're saying. When I looked at this case, I didn't. The first thing I know is because I've worked with the state before, and they normally request a jury trial on these types of charges. That's why I was wondering why this was on the case. I checked, and they did file a motion for a jury trial just yesterday, though. So what I will hear from you, Mr. Corn, is that if you want to file your written motion, have them respond to it. I will certainly take a look at everything that you want me to look at. And if it's appropriate, I'll grant your motion. Okay. I don't want to do that today because of the situation that we're in. I don't have I want to look at what you present to me, what the state presents to me, and I will consider it at that point if that's agreeable with you. As far as today goes, I'm not going to move forward with this with the bench trial for the reasons that I've already stated. But I do understand your frustration. I do understand the predicament that we put your client in. Court apologizes for that, and if you give me something in writing, I will certainly consider it. Okay.
Your Honor, I will lastly note that Mr. Yongo has been on pretrial release supervision for 2 years now, over 2 years, and he's done his bit. This delay is inappropriate, and it's just not. It's not in the best interest of justice for anyone.
Okay, I hear you, Mr. Corn. All right. Anything further on Mr. Yargo at this? But please, I encourage you to if you choose to submit something to me in writing, and the court will certainly take a look at it and make a determination before the next trial calendar. Okay. And Ms. Reiser, again, please get together with your boss. get together with your other ASGs, let everyone know that the court is just not happy with how these things, it'd be one thing if this was the first time, but I think that every time that I've come to do a bench trial calendar, that this exact same thing has happened. And I understand that, all of your considerations, your witnesses, your alleged victims, but we got to do better at moving these cases forward, because that's what the Orca calendar is here to do, is move cases forward. And the sooner you make an objection, the better it is for the court, because then I can look into whatever it is that you want me to consider. And it's frankly, it's difficult for me to consider everything that you want. If I don't have, if you would provide the law for the court, whatever it is that you want the court to consider, do that. And I'll make a genuine effort to do the best I can for both sides so that we can, properly adjudicate these cases. But let's be timely on it, okay?
Understood, Your Honor, and I will let our team know today. Going
Okay.
forward, I will ensure that happens. And I just had a quick clarification. Mr. Corn Files is, I don't know if it'll be a motion or
Working on that.
a brief. I'm just, may I have at least either 10 to 15 days to file a written response, or was there a time limit that the court would?
Of course. How much, well, I don't know what it's going to entail, but I'm happy to give you 10, 15 days, however long you think you need. I just want it to be done by the next calendar, whenever, and given that it's going to be on a trial calendar, I don't know when that calendar is, but I'm happy to give you as much time as possible. Do we?
Next one, the trial calendar will be October,
Okay.
because we've already set the August and the September.
Okay. Thank you, Ms. Jones. Okay.
And then another, just a quick question, just for my clarification, Judge, when you say you'll take Mr. Corn's brief and stuff into consideration, is that into consideration for like a dismissal of the case, or?
I'm not going to dismiss the case. That's not what I anticipate doing, unless what he files, mandates a dismissal. I think what he is wanting, from what I hear, I'll take a look at his brief, is that his client requested a bench trial. And the state did not object to him having a bench trial at the time. The state never objected, even though we were on a bench trial calendar. The day before he's to be here, and he's actually here, the state filed its notice that it wants a jury trial. So in that regards, whatever Mr. Corn wants to file with regard to that, I really do think that there should be some, and maybe there is and maybe there isn't, some time limit to if I understand the state's right to have a jury trial, but when are you going to assert your right to a jury trial? You're going to wait till again, like today, if it wasn't yesterday, but it has been done in the past, that we're all sitting here ready to go, and then the state says we want a jury trial. I don't think that's fair, but I don't, Mr. Corn will tell me what the law is, and if that's, and you'll tell me what you think the law is, and I'll make a decision on it. Is that fair?
Yes, it's fair, Your Honor.
Okay, all right. Again, Mr. Yargo, the court sincerely apologizes that we got you down here today and that we can't move it forward. But I guarantee you that the next time we have you here, we'll move it forward in some way, okay? All right. You have a good day, sir.
Thank you.
Okay, Mr. Rodriguez. Thank you. Yeah. Thank you. I appreciate it. You saved me some paper. Okay.
But this is right in the middle of that.
Yeah.
Right there.
Okay.
So they would have to do what they needed to do, because you were gonna be.
Okay, all right, thank you. I appreciate that. Let me know when you're ready, Ms. Riser.
Yes, Your Honor, I'm ready to proceed.
Okay. Good afternoon, Mr. Rodriguez. Hope you all are doing well today. Mr. Rodriguez, if you can raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. You can put your hand down, sir. Ms.
And
Riser.
Judge, for the record, I'm sorry, a lot of people confuse me, but George Stein is my partner. My name's Stephen Ward.
Oh,
W-A-R-D.
I'm sorry, Mr.
No, that's
Ward.
fine. It happens a lot.
I know your face, I see, but I see your name that's on the calendar. So, good afternoon, Mr. Ward.
It happens.
Yes, Your Honor, this is the case of State of Georgia versus Marcus Rodriguez, case number 22 CR 006151C. Mr. Rodriguez is charged with 1 count of DUI alcohol less safe and 1 count of open container. The state and defense have reached negotiated plea agreement. In regards to count 1, the state will be amending that to a reckless driving. The state's recommended sentence is 12 months of probation, a $1,000 fine, 40 hours of community service, an alcohol drug evaluation and any treatment if deemed necessary, 1 risk reduction, 1 victim impact panel, to enroll and complete the ASAM level 1, to install an ignition interlock on the defendant's vehicle, to remain compliant with his doctors at Kenneth Goolsby, MD and Associates, and at least submit monthly reports to probation of his compliance, and also remain compliant with his Ridgeline counseling, which he goes to on a bi-weekly basis. So if we could have those reports submitted to probation as well. To have no alcohol or drugs without a legal prescription, and have random screens. And it's my understanding his treatment with Georgia Recovery will screen him, and Mr. Ward will correct me if I'm wrong, they screen him in his process for ASM level 1. So I don't think it'll be necessary for probation to screen him if the court's okay with that. But I just wanted to place that on the record. And then for count 2, state's recommended sentence is a $200 fine to the open container violation. And the
Okay.
state is requesting probation for the entire period of the 12 months, given this negotiated agreement and the conditions that defense and I have negotiated and agreed upon.
Okay, so just for paperwork's, I see that you've amended it to reckless driving within the body of the plea. I don't see, the charges only say DUI and open container. Nothing's indicated regarding the reckless. Do you want to put something on the main paperwork to make sure that it's properly amended to reckless?
Yes, I can write it in my an initial that I'll amend it to reckless.
Okay, okay.
If the court's okay with
Thank
that, and
you.
Mr. Ford's okay with that.
Yeah, we're okay with that, Judge.
Thanks. You going on vacation? Have a good one.
And Judge, I'll be amending the DUI charge in our docket. Once that plea goes through, I normally wait till I have the plea go through
Okay.
before I amend something, but I will amend it.
Okay. Yes, Mr. Ward.
Judge, those are the terms that we negotiated. The alcohol and drug evaluation was done last Saturday. And we'll have a copy for probation. He has completed the risk reduction program. He began his ASAM level 1 group meetings last Saturday, and he's going to be going a minimum of 3 hours a week. And I think he's able to do more. He's trying to fine tune his work schedule, his family schedule, and all that. But he's anxious to get through it and to participate. The ignition interlock device, we have a installation date of tomorrow morning at 10:30, and we will provide that to probation once that's in. He will continue to go see his doctors. Without getting into all the details of this, one of the reasons this event occurred was that he came off his medications. Judge, he's on Abilify, he's on Trazodone, and he's on Adderall RX. There are involved some mental health concerns here and that, but he's been dealing with those for a while. He got off his meds. It created this horrific situation. He's back on track. He's been back on track for quite a while. He's got the support of his family. As a matter of fact, his wife's here today. And if I'm not mistaken, you are an RN, correct? Yeah. So she's very helpful. His work has stood by him during all this, which is, at least to me, it says probably more than most, because he works for a company that just does not put up with DUI type charges, things like that. And they have really supported him. And he will be able to keep his job with the negotiated plea that we structured. He's got, I think, one daughter in college now, and the other one's starting. So for lack of a better phrase, he was really sweating this, because he would have lost his job and things would have probably imploded. And I wanted to put on the record how grateful I am to Ms. Reiser for working this out.
Very good. Anything further before I take the plea?
We just ask you accept the plea as negotiated, Judge.
Mr. Rodriguez, it's my understanding that in case 22 CR 006151C, you wish to plead guilty to reckless driving in open container. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this afternoon?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I will accept the plea as negotiated with all the terms. Were there any other special requests that, other than what we discussed, that you needed for me to?
Judge, Georgia Recovery will test him. They do ETG testing.
I have no objection to that.
Okay, just so he's not being double tested,
Right.
and we'll get a waiver which allows Georgia Recovery Centers to share that with probation.
Okay, that's fine with the court. If nothing else, Mr. Rodriguez, good luck to you, sir. I'm glad that you all were able to properly work this out, and that you've been proactive in doing some of these things that you will be on probation for. Unfortunately, you'll have to be on probation for the entire term, given the plea. But I wish you the best of luck.
Thank you, Your Honor.
Nothing further.
And we'll meet with probation today, or?
Normally we don't. I allow him
They'll
a
call.
week or two, but we will give you information of where you need to, where you need to contact. So if you can go to report to probation, let's say in the next 2 weeks or so, to get that started, but we will give you the paperwork for that today.
Very good. Thank you, Judge.
All right. And Ms. Reiser, are you all going to try to?
Yes.
Okay. Okay, very good.
I have a quick question about the August 8th jury trial calendar. Is that are you moving that?
Judge Law.
Okay.
So apparently I won't be on a jury. My jury trial calendars will be in October and November.
Okay.
Okay. Ms. James, I have set some jury trials. Would you, and I don't know, they'll be moved to me? Oh, okay. All right, that's what, you're on it.
Okay, in order to do that, I had to do your stuff so you can.
Okay, okay, good. Thank you. Thank you. I appreciate that.
September trial calendar is going to be CIT cases, because we have them in it.
Well, good. I'm glad to-
So that's why law will have regular order in August. CIT in September.
Okay.
We will have regular orcas in October, and then we have enough CIT cases. We will do that in November. If not, then we will do another regular orca. Because I didn't want to mix it.
Okay, okay,
CIT trials.
Right,
1 month, and then regular work will be the next month.
okay,
Yes. Gotta keep these things moving.
court is going to be in recess for the next 5 minutes or so. So I take it that you weren't able to work anything out.
No.
Okay, all right, okay. As such, court's dismissed for the day. I believe that's everything that's on the calendar. Thank you all. We appreciate it.
Oh, I see. Hold on.
Special conditions.
Yeah, let's-